This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
What is the citation? 2024 15 SCC page 1.
Let's check it. Just check.
Yes, para 20.
No, well, just a minute. Can you hold on for a second?
এইখানে খালি হটস্পট দাও তো।
Yes. Paragraph Millard 44 onwards. No, Millard, for better appreciation of mine, Millard, may I just proceed from paragraph 34?
Yes.
We have considered the rival submissions in the backdrop of the protracted litigation between the parties, which has led to the passing of multiple orders by this court and the High Court, a brief reference to which has already been made. The relevant records have also been perused. It may be seen that the instant round of litigation is triggered by the single judge's judgment against which the highly belated intra-court appeal has been summarily dismissed by the division bench of the High Court. We are thus required to scrutinize the single judge's judgment to determine whether the consequential directions issued therein are justified and tuned with the previous rounds of litigation. Then, Lordship, kindly come to the next paragraph, paragraph 37. In our considered opinion, there is nothing in the order dated 8 December 2010 on the basis of which the single judge of this High Court could draw such sweeping inferences. All that this court unequivocally said was that in light of the proposed policy decision taken by the state government to rectify the pay discrepancies and to grant certain reliefs to the respondents of their cadre, makes no issue survive for adjudication. To elucidate more simply, this court was satisfied that the proposed policy was fair enough to close the pending lease. As a follow-up, the state was obliged to formalize and give effect to the said proposal, which the appellants eventually did through the 2011 order. However, the learned single judge, while relying the court's decision in Supreme Court Welfare so-and-so, made two pertinent observations which you propose to analyze. I am skipping over without detaining my lord with that. Then kindly come to my lord, paragraph 44. We may now advert to the observations made by the High Court regarding the state allegedly rendering its order dated 6th May 2002 nugatory through its executive actions. High Court, as a matter of principle, has rightly held that the state has no authority whatsoever to annul a court decision through its administrative fiat. Even legislative power cannot be resorted to overrule a binding judicial dictum, except that the legislature can remove the basis on which such judgment is founded upon. However, these settled principles may not be attracted to the facts and circumstances of the instant case. Nevertheless, the settled principle is state cannot, either by executive order or legislative order, negate a judgment.
Yes.
And here, the state scheme is based on the Supreme Court judgment. They refer to the Supreme Court has declared that the appointments are all bad, illegal. Now state wanted to protect them. They say, because of Supreme Court judgment, they have become payless. Therefore, we give them pay. That's the that's the scheme. Now kindly come to the Supreme Court judgment, the relevant portions. The page 63 of the petition.
Yes.
The last question relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates were appointed must be terminated, and they should be required to refund Kindly see the direction. Refund any salary payment received since their appointments were the result of fraud and this amounts to cheating. Therefore, we show no justification to alter this direction. Where the Supreme Court is asking that they have to refund the money which they have earned by virtue of illegal appointment. Now, scheme says we want to protect you by giving you pay. Well, this is direct confrontation of the Supreme Court judgment. And then next paragraph is also important. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to the egregious violation and illegalities which violated Article 14 and 16 of the Constitution. As such, the appointments of these candidates are cancelled. However, candidates who are already employed need not be asked to refund or institute any payments made to them. However, their services will be terminated. Furthermore, no candidate can be appointed once their entire examination process results have been declared void. Now, from this ballot, they preferred a MA application, and that application is also very interesting. State preferred an application on which the Honorable Supreme Court passes an order at page 66.
Yes.
Here below, state was specific about the teachers. We are inclined to accept the prayer made in the present application insofar as it relates to assistant teachers for class 9, 10 and 11, 12, not found to be tainted, subject to the following conditions. Lordship may skip over, then kindly next page. We are not inclined, I got it?
Yes.
To accept the prayer in the present application insofar as non-teaching posts in Group C and D are concerned, as the number of appointees specifically found to be tainted in the said groups is substantively high, and secondly, what has prompted us to pass this order in respect of assistant teachers not found to be tainted is that the students undergoing study presently should not suffer on account of the lack of teachers and the lapses and failures which have resulted in order passed by this court. Therefore, even their MA application, Supreme Court is very strict that no Group C and Group D candidate will be given any benefit because majority were found to be tainted.
Correct.
Now, thereafter, there were 180 review applications, 180, I am told.
Yes.
All were dismissed by the Supreme Court.
Page 9 of the affidavit in reply.
And apart, this is the factual background, and the state government has practically filed an affidavit just reiterating the scheme, nothing else.
Affidavit in reply to the opposition of the state. Page 9. Yes. This is the order of review, my lord. And the order is at page 19. It starts from page 9. The portion is at page 19. Starts from page 9. Yes.
Now, therefore, the basic principle, if I do not want to, pile up with more judgments. Another judgment I can, cite, where the Supreme Court said that by administrative power or legislative power, you cannot negate a judgment of the court. That is, again, 2011, 5 SCC 227.
2005?
2011.
2011.
5 SCC 227. Mr. Dashgupta will cite this.
Yes.
2011 5 SCC the apparat. But the 227, the relevant paragraphs, I am just pressing a lordship. भूल लिखेছে রে বারোয়াট লাগবে না, এটা ভুল লিখেছে, মহা মুশকিল ছে 2005 না 8 বোধ হয়।
Yes, Mr. Bhattacharya.
Yes, my lord, I am just now citing, my lord, that 1990 volume 4 SCC, my lord, that was a wrong, my lord, quotation.
2011, volume 5, you are not relying that?
Not now, not now. My lord, before that, I shall, my lord, place, my lord, that the article 144 is to be complied with by all. That is Supreme Court Judgment 1990 for SCC, page 627. I mean, 1990 দেখানে হবে। উফ,
Hello, time.
1990 volume 4 Supreme Court cases, page 627.
Page?
627.
Yes.
80 দেখো তো। I'm not. Well, kindly comes to me, Lord, the paragraph 5 and 6.
I am giving the copies.
Your juniors are not ready with the citation here.
I shall file a short note for your lordship. I'm just reading out, Lord, loudly reading out for my lord's consideration. Well, I'm just reading out, Lord, the stricture in the language is such that before we part with the case, paragraph 8, we would like to again administer a warning to everyone associated with the scheme for implementing the directions contained in the main judgment and the subsequent orders that a future default by anyone in any part of the country shall indeed be seriously reviewed and drastically dealt with. The court has stated in the past, and we would like now to reiterate, that directions of this court are not intended to be brushed aside and overlooked or ignored. Meticulous compliance is the only way to respond to directions of this court. This strict language, my lord, was issued by the Honorable Bench presided by Justice Ranganatha Misra.
Yes.
1990, Volume 4 SCC, with regard to, my lord, the effectivity of Article 144. Therefore, my lord, I don't think, my lord, I have to cite any other judgment, my lord, to satisfy the court that the constitutional court has to implement the constitutional principles, and the Supreme Court judgment, highest court, even after dismissal of review, of course, they were quite conscious. Therefore, they say the scheme will valid up to the final order of the Supreme Court, since their review was pending. Now it has become a nullity.
Yes.
But these are my humble submissions.
Thank you. Yes.
Lord, the state would respond with regard to the scheme. My lord, we are, my lord, the untainted non-teaching staffs. If your lordship, my lord, I also rely upon page 46 of the Supreme Court order, my lord. My lord, what is 46, para 46 at page 63 of the date petition, my lord. Vaishaki Bhattacharya judgment, para 46, 45 and 46, my lord. 45 is exclusively for the tainted teaching as well as non-teaching. They will not get any benefit.
You are appearing for?
Well, we are untainted,
Untainted.
non-teaching. Well, for whose benefit this scheme has been passed. Well, this is my submission. Well, 45 tainted would not get anything, and
Correct.
they will also have to refund the salaries that they have received. 46, my lord, kindly considers
Yes.
the candidates not specifically found to be tainted. The entire selection process has rightly been declared to be void. My lord, these appointments are cancelled. They are not liable to refund their salaries. No candidate can be appointed once the entire examination process and results have been declared void. My lord, we come within the purview of this untainted category of non-teaching staff. So, for untainted teaching staffs, the protection has been granted by the Honorable Supreme Court, where they have been allowed to go back to their schools.
Correct.
They are getting benefits,
Correct.
service benefits,
Correct.
some service benefits, if not all. But we are the untainted non-teaching staffs who have lost their jobs and we have nothing. Untainted. There was a point of time when there was this tainted and untainted categories of non-teaching staffs could not be separated. Now it has been separated. A specific list of tainted non-teaching have been uploaded, and the rest remains untainted. Lordship kindly sees the scheme once, appearing from page 70 of the writ petition.
So how the 46 will be applicable to you?
46, I am saying that the scheme does not violate para 46. The scheme does not give anything which para 46 has barred. Kindly sees the scheme. What has been sought to be portrayed that the scheme will be applicable for all the tainted as well. That is not. Kindly sees the preamble of the scheme and the definition of distressed family. Para 70 onwards. Page 70.
Yes.
The governor is pleased to introduce the following scheme to provide limited livelihood support and social security on humanitarian grounds and on purely temporary basis, subject to consequential order of incompetent court, to the distressed families of non-teaching staff in Group C and Group D categories who were recruited through the 2016 selection process conducted by the West Bengal Central School Service Commission, and who have lost their jobs and whose salaries have been discontinued for reasons beyond their control.
So if that be so,
My lord.
If any person leave aside this matter,
My lord.
A is appointed, B has challenged.
My lord.
Subsequently, it is found no, the B is eligible. Let the A is eligible. Let the A B be appointed. B service to be terminated. Can then the state will go, okay, we have
What has happened, kindly considers in this particular case, X has challenged the recruitment process of A, B, and C.
Correct.
The court finds that A's appointment was illegal, and hence B and C will also have to suffer the cancellation of the entire appointment. So B and C's appointment goes,
Total process has gone.
total process goes, though B and C are certified untainted candidates
Correct.
who did not have any on their part.
Correct.
So this has been done in this particular case.
But
It's not that
Have you filed the review application? You are not the untainted. You may be allowed to continue.
Yes, my lord, because the Supreme Court was clear that
Not
we were
even that.
providing this protection only to the teaching staffs so that the schools may not
Continue.
stop.
Correct.
The education may not stop.
Correct.
And we are not inclined to give this benefit to the non-teaching staff because the number of the tainted category of candidates are more in this particular group. Now the list of tainted and untainted are separate. We have been able to identify who are the tainted and untainted candidates. There is specifically 3,512 who have been identified as tainted. I'm considering all the aspects of tainted category. 3,512, both Group C and Group D. And
The tainted.
tainted. And 3,394 are classified as completely untainted. Who have lost their jobs, beyond their control. For reasons beyond their control.
These are the non-teaching staffs.
My lord.
Yes.
And my lord kindly considers the definition of distressed family. 2A.
Yes.
2A, distressed family has been defined, which means the immediate family of any non-teaching staff in Group C or D category who was recruited through the 2016 selection process conducted by the West Bengal School Service Commission, constituted under the School Education Department, Government of West Bengal, and who has lost his or her job due to the said judgment and whose salary has been discontinued for reasons beyond his or her control as a consequence of such co-workers, my lord, the same line, my lord, who has lost the job for reasons beyond his or her control. My lord, here comes the untainted category, not the tainted one. So, my lord, what ought to have been projected that this scheme will benefit the tainted candidates as well, my lord, it is absolutely, my lord, does not have any, my lord, basis.
Okay. So now what is happened when the Supreme Court matter is over?
Supreme Court review has been, my lord, dismissed, but thereafter several applications, my lord,
Now kindly come to 72(6), which they are 6(3).
yes.
What is
My lord,
your
this is
answer
the
to
limitation
that?
of the benefit. The benefit of the scheme upon this will discontinue upon the proceeding before the Honorable Supreme Court arising out of my lord Boshagi Bhattacharya's case, attaining finality through final disposal of the review petition, or any other further petitions as may be filed in accordance with law by the Supreme Court of India, whichever is earlier. The last order that we have found, my lord, Vivek Paria's order, where the Supreme Court has, my lord, dismissed the other several applications connected in, my lord, filed in connection with Boshagi Bhattacharya's matter, and that this is in, my lord, November, 23rd of November 2025, 26th of November 2025. And this scheme, my lord, was supposed to, my lord, commence from 1st of April 2025. This particular scheme, promulgated in May 2025, effect has been given from 1st of April 2025.
Yes.
So, my lord, at least, my lord, I do not know what other matters are pending that the state and the School Service Commission will be able to, my lord, apprise your lordship better. But at least till November 2025, from 1st of April, my lord, this untainted category of candidates non-teaching are entitled to this benefit.
So you said
And my lord,
till the disposal of the
yes. And my lord, kindly sees the, my lord, the filter that is there in the scheme itself. My lord, 3, clause 3,
Yes.
at page, my lord, 71.
Correct.
My lord, the scheme provides for a screening committee. A screening committee is hereby constituted with the following members of for the purpose of determining the eligibility of the distressed families. So, my lord, it is not that anybody who has lost their job in 2016 selection procedure will come and apply and they will get the benefit. No. Only, my lord, if the screening committee is satisfied that they have lost their job for reasons beyond their control, which means, my lord, untainted, only then they will be, my lord, given the benefit under this scheme. And how much is it, my lord? 25,000 for the Group C and 20,000 for the Group D, untainted. And this is, my lord, this has been, my lord, the scheme has been formulated under in exercise of the power under Article 162 of the Constitution that Learned Senior has already, my lord, apprised your lordship. Who are the petitioners before your lordship? Petitioners. My lord, this scheme, if I say, it's, my lord, 3,394 candidates. And applicants are only some of them. My lord, the petitioners before your lordship are two persons. One, my lord, claimed to be a Group C, my lord, waitlisted candidate, and the other one claimed to be a Group D waitlisted candidate in the 2016 process. But other than these two petitioners, nobody has challenged this particular scheme. And the scheme, my lord, after being formulated, has been, my lord, stalled, my lord, owing to the, my lord, the order.
One is petition number one is?
My lord, petitioner Prakash
Is
a group, my lord, kindly see para 1. Not 2, my lord. Your petitioners state that your petitioners have the requisite qualification for being appointed in Group C and Group D post in any non-government aided and your petitioner states that the West Bengal Central School Service Commission published an advertisement, they participated and they have been issued admit cards, but they were waitlisted candidates.
yes.
And my lord, kindly sees paragraph 9 and 15 of the writ petition. 9 is, my lord, what they sought to portray, that all the beneficiaries under these schemes are, my lord, illegal appointees, which is not true. And para 13, my lord, I'm sorry, para 13 at page 12, the lordship will find that they also want to be included under the scheme as beneficiaries. This is their grievances that since they were not considered as beneficiaries under the scheme, that is the reason they have challenged this. So where is the challenge to the scheme? They were basically, my lord, aggrieved by the fact that they were not included in the scheme. My lord, kindly considers our position. After working for 7 and 8 years, my lord, without having fault in our part, my lord, our services were, my lord, terminated.
Yes.
And from, my lord, April till now, we are surviving without any means. And distressed family, the definition of distressed family does not, my lord, include only the candidates. It also includes the family members of the candidate. Some of them, my lord, it is coming from the bar, but some of them might have committed suicide. What about the family members of them?
Okay. That's all. Anything further?
My lord, the scheme, my lord, provides, my lord, a very, my lord, a detailed procedure. My lord, I'll have to apply. Screening committee will process. If somebody has any grievance, there is a provision for appeal. Appellate authority is there. There are, my lord, limitations on the application of this scheme, which has also been, my lord, specifically, categorically mentioned in this scheme. So, my lord, this is for the untainted. What is being, my lord, projected, my lord, that all the beneficiaries are, my lord, illegal appointees, my lord, that is not correct. This is, my lord, targeted for the untainted category of candidates.
Okay.
My lord.
Thank you.
May I reply?
Now let the state
Oh,
complete.
state. Oh, sorry.